Hi, everyone. Thank you for joining us today for Constangy's webinar, the H-1B Visa Landscape, Current Trends, Policy Shifts, and What Employers Need to Know. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters may not be able to address all of your questions during this session, but we encourage you to reach out following the presentation. Their contact information will be included in our post-webinar follow-up email. This program is approved for SHRM and HRCI credits. We'll be sharing those codes at the end of this presentation, so please stick around in order to get them. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Justin Coffey and Kelly McGrath.
Thank you so much and welcome everyone, and thank you for joining us today. Just to introduce myself, my name again is Justin Coffey, and I'm co-chair of the Immigration Practice Group at Constangy and a partner in the firm's Raleigh office. My practice is devoted exclusively to immigration, and within that, particularly employment-based immigration. Our other speaker today is Kelly McGrath, who's an associate also with the Raleigh office, but physically located in Atlanta, Georgia. Kelly also specializes in immigration and specifically employment-based immigration. Just a note about our program today, we're going to be focused largely on hot topics in the H-1B space, which there's a lot going on. I just want to note that this is not intended as a primer on H-1Bs. This is not a 101 on H-1Bs. This is a more advanced topic. So the assumption is that you have some basic familiarity with the H-1B program and immigration processing in the United States. Later, Kelly is also going to touch on some current events going on with respect to international travel and trends that we're seeing in requests for evidence. So with that, we'll jump right into it. So if you haven't been under a rock, you may have heard about the presidential proclamation that was issued on September 19th and went into effect the next day at midnight, 12:01 a.m. on September 21st. This presidential proclamation imposes a $100,000 fee on H-1Bs, and specifically the proclamation states that foreign nationals whose H-1Bs were not filed with the $100,000 fee would be restricted from entering the United States. The legal authority that the proclamation relies on is Section 212F of the Immigration and Nationality Act, which gives the president broad power to restrict the entry of foreign nationals into the United States. And the proclamation states that entry is restricted for H-1B workers except for petitions that have paid the $100,000 fee. During the signing of the proclamation, Secretary Lutnick also indicated that this $100,000 fee would be an annual fee that would apply each and every year. Now, later that was walked back, and we'll talk more about that as well. Because this restriction went into effect on midnight, and it restricted the entry for anyone who had not paid the fee, many immigration attorneys, including myself, were scrambling to contact our clients and alert them that if they had H-1B workers overseas and they did not return before midnight on the 20th, they would be unable to re-enter the United States unless the $100,000 fee was paid. Another item that was later walked back, and we'll talk about that. The proclamation also contains a national interest exception. And the proclamation states that the Secretary of Homeland Security may issue discretionary exceptions to the $100,000 fee. And those exceptions can be issued on an individual basis, company-wide, or industry specific, right, for the entire industry. The criteria referenced in the proclamation for the exception is that the hiring of the foreign national should be in the national interest, and that the foreign national worker does not pose a threat to the security or welfare of the United States. So the next day, we started seeing various types of guidance start to trickle out. Initially, this was through tweets and other similar postings. So, for example, here, the White House press secretary indicated that it's not an annual fee, right? Contrary to what was stated during the signing of the proclamation, that it's a one-time fee, and that individuals who already hold H-1B visas and are outside the United States would not be charged the $100,000 fee to re-enter, that travel would not be impacted for current H-1B visa holders, and that this would only apply to new visas, not renewals, and not current visa holders, and that it would first apply in the next upcoming lottery cycle. That's referring to the annual H-1B lottery, which will next occur in the spring of 2026. There was then a USCIS guidance memo issued on September 20th, indicating that the fee only applies to prospective petitions that have not yet been filed, that the proclamation does not apply to foreign nationals who are the beneficiaries of petitions that were filed prior to the effective date of the proclamation, does not apply to beneficiaries of currently approved petitions, or individuals who are in possession of a validly issued H-1B visa. We then saw a posting on the Department of State's website indicating that the restrictions on visa issuance and entry apply only to foreign nationals seeking visa issuance or entry into the United States based on petitions filed after the effective date of the proclamation. USCIS and the Department of State then issued FAQs, and their FAQs largely mirror each other. Those FAQs state that the payment would be required for any new H-1B visa petitions after the effective date of the proclamation, that it would apply to the 2026 lottery and H-1B petitions submitted after the effective date of the proclamation, and the fee would not apply to any previously issued H-1B visas or petitions filed before the effective date of the proclamation. It does not apply to H-1B renewals, and is a one-time fee on the submission of a new H-1B petition. And that would not prevent any holder of a current H-1B visa from traveling in and out of the United States. CBP then issued a guidance memo stating that this only applies prospectively to petitions that have not yet been filed, would not impact beneficiaries of currently approved petitions, petitions filed prior to the effective date of the proclamation, or to those in possession of a validly issued H-1B visa, and would not impact the ability of current visa holders to travel to or from the United States. It also indicated that USCIS and the State Department have been instructed to begin implementing the new payment for employers submitting petitions on behalf of individuals outside the United States and for new H-1B petitions only. Then a month later, about 10 days ago, the USCIS updated their website with yet additional information and some significant information. So the website update issued on October 20th states that the fee does not apply to H-1B extensions, amendments, or change of status petitions filed within the United States. Now, it also indicated that if any of these petitions were only approved for consular notification, the fee would apply. So if you file for an extension of status for an H-1B worker and it's only approved for consular notification, meaning that that H-1B worker would have to travel to activate their H-1B status and apply for a visa stamp, then the fee would apply. Okay. It also indicates that beneficiaries of approved petitions for extensions, amendments, or change of status would not be required to pay the fee if they depart the United States. That the fee would just apply to petitions filed after the effective date and for consular notification. Now, what's not clear is what if an individual is in the United States, holds a valid H-1B visa, and their petition, for example, for an extension of stay is only approved for consular notification. Would the $100,000 fee apply in that scenario? And that's not clear. We do not believe we know the answer to that question. In addition, the website updated guidance adds information regarding the national interest exception, and it states that it may be granted in extraordinarily rare circumstances and adds a requirement that U.S. workers are not available for the role. And that does not appear in the original proclamation. The guidelines on the website with respect to the national interest exception appear to only reference individuals. There is no reference to obtaining exceptions that apply to a company or an industry. So it appears to be more limited than the language that appears in the proclamation. So that's a lot of various types of guidance issued by various agencies. And when we add all that together, right, where does that leave us? Well, what we know is the fee should not apply to extensions, amendments, and change of employer petitions filed in the United States that are not for consular notification. That includes change of status petitions for the upcoming 2026 lottery. The fee should not apply to cap subject H-1B petitions going through the lottery if they're filed for change of status and approved as a change of status. And we also know that the fee does not apply to H-1B petitions filed before the effective date of the proclamation, and that it does not apply to H-1B ones for citizens of Singapore and Chile. It does apply to cap exempt employers that file H-1B petitions after the effective date of the proclamation. And we have seen reports of cap exempt employers filing H-1Bs that are receiving requests for evidence the $100,000 fee. Okay. And again, it will apply to petitions filed or approved for consular notification. And it may apply to a foreign national with a valid H-1B visa who has a petition approved only for consular notification. That is the point we are not clear on at this time. With the additional guidance from the USCIS website, it does change the national interest exception as originally stated in the presidential proclamation. What we appear to have now is a 4-part test to be eligible for the national interest exception. First, it's got to be an extraordinarily rare circumstance where the Secretary of Homeland Security has determined that a particular worker's presence in the United States is in the national interest. Two, there has to be showing that no American worker is available to fill the role. Now, let me pause there. There's no such requirement in the H-1B statute, and there's been no guidance about how to make this showing. So, for example, in the employment-based immigration context, there are firm applications for green cards that involve labor market tests. Are employers going to be required to go through a labor market test, advertise the H-1B role, extensively interview candidates, and if no American workers are located, document that and provide that to DHS. It's not clear how an employer is going to be expected to make that shown. Okay. The third part of the test is that the foreign worker does not pose a threat to the security or welfare of the United States. And then finally, you have to show that requiring the employer to make the payment would significantly undermine the interests of the United States. So this appears to be quite a high bar to pass in order to get a national interest exception. We also created a email address, which is on the slide, where employers who are requesting a national interest exception are supposed to email their application for the exception and include all of their supporting documentation. So, not surprisingly, the proclamation has been subject to litigation. There's been two cases that have been filed. The first case was filed early this month in California. And the second case was filed a couple of weeks ago in Washington, D.C. That was filed by the U.S. Chamber of Commerce. So we'll have to see how this litigation plays out. And without going into a lot of detail, at a high level, I think that there are a few interesting issues that this litigation raises. First of all, the H-1B statute does not include eligibility criteria that the proclamation is imposing. So there, I think, is a good argument that the proclamation exceeds the power of the president, because it's essentially rewriting a statute created by Congress. I think that's a significant issue. Additionally, the $100,000 fee could also be viewed as a tax and spend provision. And tax and spend is the power of Congress, not the president. So I think that's another significant issue to be litigated. Additionally, there's no rulemaking as part of this proclamation. There's no regulation issue. So that would appear to be a violation of the Administrative Procedures Act, because the rulemaking process was not followed. Now, some lawyers, I might be one of them, would argue you can't even do this through regulation. But the point is, there was no attempt to do this through regulation. There was just a presidential proclamation with no rulemaking, no notice included. Now, another potentially significant piece of this proclamation is that it directs the Department of Labor to engage in rulemaking to review prevailing wage levels. Prevailing wage levels, as a reminder, right? Prevailing wages are used in H-1B and other types of immigration petitions. And there's no time frame specified in the proclamation for this rulemaking process. So what should we expect from revised prevailing wage levels? Well, the prior Trump administration issued two regulations trying to revise prevailing wage levels. So we can look back to the actions taken in the first Trump administration to see what we might expect with a new prevailing wage rule. So just for some background reminder here, how this data is used. Prevailing wage data is based on occupational employment statistics from the Department of Labor. It's OES wage surveys. And it just has a 4-tier structure. There's only 4 wage levels used. Wage level 1 is the lowest wage level. Wage level 4 is the highest wage level. Under the current system, wage level 1 is the 17th percentile of the OES wage distribution. Wage level 2 is the 34th percentile. Wage level 3 is the 50th, and wage level 4 is the 67th percentile. The first rule that was attempted under the first Trump administration was issued 5 years ago this month, October 8th, 2020. And under that rule, the wage level 1 would have moved from the 17th percentile to the 45th percentile. So a huge jump for wage level 1 and a huge jump for all of the wage levels. Wage level 2 would move from the 34th percentile to the 62nd percentile. Wage level 3 would jump from the 50th percentile up to the 78th percentile, and wage level 4 would have jumped from the 67th percentile to the 95th percentile. Now, this rule had some significant issues. It went into effect immediately with no advance notice, and the rule was quickly enjoined by the courts based on both procedural and substantive rulemaking violations. So, the administration issued a second rule on January 12th, 2021. And the rule tried to take into account some of the issues identified in the litigation over the first rule. So the increases to the wage levels were not quite as dramatic, it was still very significant. So under the second rule, wage level 1 jumped up to the 35th percentile. Wage level 2 jumped up to the 53rd percentile, and wage level 3 jumped to the 72nd percentile, and wage level 4 went up to the 90th percentile. So still very significant increases in wage levels, just not quite as significant as in the prior rule. This rule also had a more complicated implementation schedule. So there's a staggered implementation where during the first 12 months, the prevailing wages would be set at 90% of the new level before going into full effect. Additionally, there was a more complicated staggered implementation for H-1B workers that were eligible for post 6-year extensions of their H-1B. So these are H-1B workers who were far enough along in their green card process that they were eligible to extend their status beyond the normal 6-year limit. So for those workers, during the first year, wages would have been set at 85% of the new levels. And the second year, they'd be set at 90%. During the third year, they'd be set at 95%. And at the fourth year, 100% of the new wage levels would apply. Again, this rule was subject to litigation, and ultimately it was vacated by the courts, and later the Biden administration withdrew that rule. So with respect to a new proposed prevailing wage rule, we don't know exactly what will be in it, but I think that we can look to this rule as likely a model of what they will base the new rule on. It will probably not be identical to this, especially given that this rule was vacated by the courts. But it probably will be modeled on this rule and may have some similarities. And I think the expectation generally is that we will see potentially significant increase in prevailing wages. We also should expect that if there is a rule issue that significantly increases prevailing wage levels, that we will likely see litigation around that as well. So that is our presidential proclamation update. We have another significant change with the H-1B program, and that is a proposed regulation for the H-1B lottery process, the annual lottery process, right? So every year there's a annual lottery for new H-1B subject to the annual quota or H-1B count, as we call it. So this proposed regulation was published on September 24th, had a 30-day notice and comment period that's already closed. The proposed rule would change the current random selection process to a weighted selection process based on results. And the weighted selection process would favor higher wage levels, which essentially would result in significantly fewer H-1B selections for entry-level workers, entry-level employees. Now, this would only apply to new H-1Bs subject to the annual quota, right? It would not apply to extensions, amendments, change of employer petitions for individuals who already hold H-1B status. So comparing the current process to the new proposed process, okay, currently the way the process works is employers submit an H-1B registration for each employee they wish to enter into the annual lottery. Each registrant is entered into the lottery only once, regardless of how many employers might submit registrations for the same employee. Under the new proposed process, the number of times that the registrant would be entered into the lottery depends on the wage level that corresponds to the employee's salary. So no longer a random process, right? It would be based on wage level. So how does that work? Under the new lottery process, the proposed, I should say, lottery process, if a registrant's salary would be at corresponds to wage level 1, they would be entered into the lottery one time. If their salary would correspond to wage level 2, they would get 2 bites at the apple, right? They'd be entered into the lottery twice. And at wage level 3, they're entered 3 times, and at wage level 4, they're entered 4 times. Currently, the chances of being selected in a random process that we have are approximately 30%, regardless of wage level, right? According to the government's data, which I'm going to rely on their data, because that's all we have. So I can't speak for its accuracy, but according to the government's data, under this new process, the chances of being selected in the lottery would change in the following way. If someone's salary corresponded to wage level 1, they would have approximately 15% chance of being selected in the lottery. Okay? So that would cut their chances down approximately by half. At wage level 2, they would have roughly the same chance that they have today, right? Approximately 30% chance of being selected in the lottery. But at wage level 3, the chances of being selected in the lottery jump up to almost 46%. And at wage level 4, the chance of being selected in the lottery is about 61%. So what that means is the wage level 1 folks have a much less chance of being selected. In the annual lottery process, many of the people being registered for the H-1B lottery are recent degree program graduates. They're F1 OPT status. Therefore, they tend to be working in more entry-level type jobs, and they're more likely to be wage level 1 or wage level 2. So this means obtaining H-1Bs for our more entry-level employees would become much more unlikely, much more difficult. The new lottery process would also maintain the current two-stage selection process. Okay, so right now, the way the lottery process works is we have the so-called bachelor's cap, the regular cap, if people have at least a bachelor's degree or equivalent, and that's set at 65,000. And then there's an advanced degree cap for individuals who hold at least a master's degree or higher from a U.S. institution, and that's an additional 20,000 H-1B for a grand total of 85,000. So right now, the way the process works is everybody, advanced degree and bachelor's, are run through the bachelor's cap of 65,000. Individuals with advanced degrees who are not selected as part of that bachelor's cap then get run through the advanced degree cap. That would be maintained, but the weighted selection process would apply to both lottery processes. So that means that someone with an advanced degree who's at wage level 4 would be entered into the bachelor's cap 4 times. And if not selected in the bachelor's cap, they would then be run through the advanced degree cap and entered into that lottery 4 times. Now, I was not a math major, which is why I went to law school. But by my math, 4 plus 4 equals 8. So that's 8 bites at the apple for that individual under the lottery process. Now, what about workers who might have multiple registrations submitted on their behalf by different employers? How many times would they be entered into the lottery? They may have different wage levels that apply to different registrations. Well, under this rule, they would use the lowest wage level of all the registrations submitted on their behalf. So if they have multiple registrations and one's at wage level 4, one's at wage level 1, they would use wage level 1 for lottery purposes, and they'd only get entered 1 time. What about registrants who might work in multiple locations that may have varying wage levels? Same thing. The lowest wage level would be used, right? So if they have at one location, if they're wage level 3, in a different location, they'd be wage level 1, they would be assigned wage level 1 for lottery purposes. Now, it may occur to some people that employers could try to game the system by initially filing for an H-1B registrant at wage level 4, and then later maybe filing an amended petition to reduce their wage level, right? So the proposed rule indicates that if employers attempt to do that, that subsequent petition could be denied. So you can't game the system by filing an initial petition for a higher wage level and then later file to lower the wage level to try to game that system. And of course, with this new rule, additional data would be required to be submitted as part of the registration process regarding wage information and other details. And if there's discrepancies between the registration data and the petition that's later filed, that can result in a denial of that H-1B petition. So the notice of comment period is closed for this proposed rule. A number of associations, organizations have submitted public comments. U.S. Chamber of Commerce has submitted public comments opposing this rule, as has the American Hospital Association, higher education organizations, and I saw that SHRM has also submitted comments in opposition to this rule. However, I do think that the administration intends to issue this rule as a final rule, and I do believe that they would like to see this final rule in place before the 2026 H-1B lottery occurs. And if it is issued as a final rule, we do expect litigation over this rule. And I think there is a good argument that the rule may exceed statutory authority, that the president may not have the power to change the H-1B selection process in this way. But of course, that will be for the courts to decide. If the final rule is issued on this and there is litigation, I would fully expect this would go up to the Supreme Court. So that brings us to our next topic, which is so-called Project Firewall. Project Firewall has been announced by the Department of Labor as an H-1B enforcement initiative. Now, it's important to note that so-called Project Firewall doesn't create any new legal authorities for the Department of Labor to investigate and enforce H-1B related regulations. The Department of Labor already has these authorities. Okay, so there's no new authorities being created here. But we think that the reason they announced this Project Firewall is to highlight the Department of Labor's intent to increase investigations of the H-1B program and investigations of employers using the H-1B program. So what should we expect from this? I think we're going to see more frequent LCA investigations and audits. So the Department of Labor, I expect, will be reviewing employers' public access folders for compliance. So now is a good time to make sure that your public access folders are compliant. They have all the documentation in that they're supposed to. We may see an increase in the Department of Labor confirming that the terms of H-1B petitions are being met, that employees are being paid the required wage they're supposed to be in the LCA, the labor condition application, that they're working in the right location. And that is also a significant issue these days because we have, in this day and age, we have more individuals working remotely. And sometimes workers decide to relocate without informing their employer, and that can put an H-1B worker out of compliance, right? Because they're only authorized to work in the location covered in their LCA and H-1B filing. And if there are violations, if it's discovered that a worker is not working in the location that they're supposed to, then you could see revocations of H-1Bs. We could also see various wage actions for back wages. So, for example, if an H-1B worker is authorized to work, in Nebraska and decides to self-relocate to San Francisco and they're not being paid the required prevailing wage, you could see back wage assessments potentially. The other thing to note of significance is that typically, historically, we've seen LCA investigations occur as a result of a complaint. An H-1B worker has complained to the Department of Labor that they think that their employer is violating the H-1B program rules in some way. They've indicated that they'll be conducting Secretary of Labor certified investigations where there have been no complaints lodged against the employer. And that would be a departure from what we have seen in the past. They're also, in this announcement, reminding us that they will share information. The Department of Labor will share information with other government agencies, including the Department of Justice, who can further investigate and prosecute employers if they feel that's warranted. We may see the frequency of the Department of Labor imposing penalties on employers increase, and we may also see the amounts of penalties increase from what we've seen historically. And we may also see increased instances of employers being debarred from using the H-1B program if they find significant and repeated violations of the program. We may also see the Department of Labor take a tougher stance on the types of violations and how they view them. So in the past, what might have been viewed as more sort of minor paperwork violations may be seen as much more serious. And we may see more aggressive enforcement and penalties apply than we have in the past. All this to say, employers using the H-1B program, now is a good time to ensure that your house is in order and that your public access folders are in order and that your H-1B workers are working pursuant to the terms and conditions as set forth in the H-1B petitions filed with the government. So with that, I'm going to turn it over to Kelly to talk about other fun things going on in the H-1B space and travel and stuff.
Thank you, Justin. Yes, so another fun thing that we've been seeing lately is an increase in requests for evidence issued by USCIS. We all love getting an RFE. It means our job is not done. So recently we've been seeing an increase in H-1B RFEs with a few different categories. So I'll go over some of those and generally how we respond to them. The good news is that with these increases, we're more comfortable in preparing these responses because they become more routine. But the flip side of that is just the delays that come with it. So one of the things that we've seen an increase on is maintenance of status RFEs, particularly those for applicants that have held CPT status in the past. But we're seeing it across H-1Bs and for other case types. For these, we need to show the foreign national has maintained their non-immigrant status prior to filing the petition. Normally for H-1Bs, we're going to provide things like pay stubs. I have seen USCIS request a longer period of time that they want to see pay stubs for, or W-2s showing that the applicant has, continued working and is maintaining their H-1B status. But for those who are maybe changing status to H-1B from F1, who have held CPT work authorization or another kind of work authorization in F1 status, those maintenance of status RFEs are a little bit different. And normally what USCIS wants to see is that those applicants were actually attending the university program that granted them work authorization. Normally we're able to respond with things like, transcripts, the applicants' tuition payments. I've seen, we've submitted the student ID. I had one person send me receipts of, they went to Taco Bell every day after class and they sent me all their Taco Bell receipts. Just showing, hey, I went to my classes in person and see, I was hungry afterwards. I don't know how much weight USCIS puts to that, but I did think it was funny. Beyond that, we are seeing RFEs for LCAs and wage levels. Justin talked about wage levels a little bit earlier. As you know, with H-1B petitions, we have to include a labor condition application that is certified by the Department of Labor. Part of that includes the prevailing wage for the role and the corresponding wage level. And as Justin mentioned, there are only 4 wage levels and they correspond to how much experience is required for the sponsored role. Well, an entry-level role corresponds with a level 1 wage. Well, in the first Trump administration, we saw a lot of level 1 wage RFEs where USCIS says, wait, is this H-1B petition, is this really a specialized occupation when, you know, it's an entry level role? Well, yes, it is. And we, you know, the great thing about these patterns is that, you know, we have really good arguments for saying, yes, this is a level 1 wage and this is why. So normally for that, we just need to show what the requirements for the role are and, you know, really show USCIS, this is entry level, it should be a level 1 wage. You know, this is for somebody that's pretty much right out of school. That's why it's at the bottom tier of these wage levels. They can be a bit complex. So if you're, you know, working with us and we're requesting a lot of information about the role and the projects that the applicant will be working on, what their day-to-day looks like, it's all just supporting our argument that yes, it is a specialty occupation, but it's also more entry level. And related to that, with the prevailing wage on LCAs, we can use the Department of Labor specified prevailing wage, but sometimes that doesn't exactly align with what our wages are for our companies. So we're allowed to use alternative prevailing wage surveys when filing LCAs. But we are seeing USCIS increasingly question that. And it's, you know, it's fine to use those alternative surveys. And when we get an RFE questioning our use of them, we, you know, similar to these level 1 wage RFEs, we're going to ask for a lot of information about the role, and we're going to really show USCIS that, hey, this alternative survey corresponds with this sponsored job, and here's why. You know, look at how perfectly these things match up. Isn't it beautiful? And so those similarly can be a little bit more complex to respond to, but as I said, the more we see them, the more used we are to responding to them and helping you through that process. Also, we have seen an increase of specialty occupation RFEs, and that's kind of USCIS throwing the whole kit and caboodle at us, saying, we're just going to question everything about this role. And so those tend to be complex as well. We're going to be asking for a lot of detail to respond to that. We're going to need information about the role requirements, how the foreign national qualifies for the role, and similar roles within the field. So this will take a bit of work between client and counsel to respond, but you know, we see them under every administration. We're just seeing a little bit more of them now. And finally, we are seeing something a bit new, which has been RFEs for biometric appointments. This is a little bit of a warning sign for us when we get these. And it's a very simple RFE at first, and it says, hey, you know, we need the foreign national to attend a biometric appointment. You know, we're going to take their fingerprints and easy peasy. But it normally is indication that there's a second RFE coming, and it normally is related to criminal issues or past arrests. And those are obviously a lot more complicated, or they can be. Depending on the severity of the second RFE, what the criminal issues are, or, you know, what the foreign national was arrested for, you know, it might be necessary to work with a immigration counsel. It might, you know, it might be something that you look at if you have rules in place about employees disclosing arrests for certain things to you as their company. And if any employment action needs to be taken with that, you should work with your employment counsel on that. And it, it's kind of a can of worms that when you get this biometric RFE, tends to mean this is coming. So these are things you can think about, but you won't know until you get that second RFE what you're dealing with. And that's when you would come to us and say, okay, Kelly, Justin, this is what we got. This is what we're dealing with. Where do we go from there? And those are very much case-by-case basis RFEs because the situation is going to be very unique for each case. So those are our RFEs, our trends that we've been seeing recently. With that, we'll move on to our next slide about travel. There have been a lot of updates recently in the travel space, which is important to touch on before the holiday season. So as I'm sure you've all heard in the news, there has been an increase in vetting of visa applicants. Social media can be vetted specifically for visa applicants for F, M, and J non-immigrant visas. And CBP can review social media for American views in visa applications, for all visa applications, and ensure that applicants are not critical of the US on social media. We are also seeing an increase of administrative processing. Administrative processing is somewhat of a blanket term, and it can refer to either a short or lengthy background checks. It will occur after a visa appointment when the foreign national has handed over their passport, they're waiting for their visa stamp, and either at their appointment or in the days that follow, they're told, you've been put in administrative processing, which can be a bit of a black hole because there's not much you can do as the employer or us as outside counsel to get more information. It is the US government doing their background checks into individuals, and there's really no way of knowing if this will take days, weeks, or months. There are certain things that can trigger administrative processing, such as traveling to certain countries that are not friendly with the US. There are other things that, we're not sure why someone gets put in administrative processing. Maybe their name is similar to somebody else's name and there's a flag and we have to just wait while that gets worked out in the system. So with the increase of administrative processing can come some frustrations with those delays, especially because it's a waiting game at that point. Also, recently we saw that visa interview waivers have gone away and India's popular Dropbox appointments. So in the past, applicants could qualify for interview waivers if they were extending their current visa stamps. Now, all applicants have to go for visa appointments. It also is including those under the age of 14 and over the age of 79, which in the past, if you were young enough or old enough, you got to skip that appointment. And now you got to show up, you got to go to your visa appointment, which is, can involve extra travel to a US consulate and extra time. There are certain exceptions to this. Those are normally in the diplomatic or official visa categories, so not what we're dealing with most of the time. But there are certain exceptions for B1, B2 visas and border crossing cards for Mexican nationals. And there's a certain ways to qualify for the visa interview waiver if these conditions apply. The renewal must be within 12 months of the expiration of the prior visa. The applicant must have been at least 18 years old at the time their last visa was granted. The applicant must be applying in his or her country of nationality or residence, and they must have never been refused a visa. And there's no potential ineligibility for the application. If all of those conditions apply, they can qualify for the interview waiver for a B1 or B2 renewal. But as always, there's an exception to every rule, and consular officers always have discretion to say, nope, we want to see you in person. And if that happens, then the applicant just is going to have to show up in person. As mentioned, India's Dropbox has also ended, which was similar to the interview waiver. It involved submitting a certain amount of documents and then being eligible for the waiver. That is no longer the case. Indian foreign nationals have to now attend visa appointments. And also, just to add a little bit more complications to the mix, they have ended third country national processing, which means that you can no longer go to a US consulate that is not in your country of nationality or residence. So if the applicant is living somewhere outside of the country where they're a citizen, but they are living and working in that country, they can apply there. But if you're living and working in the US and you're from India, you can't pop down to Mexico and go to the US consulate to get a new visa stamp anymore. So that is increasing wait times, of course. So we're seeing that a lot for Indian foreign nationals, especially. Visa wait times are quite lengthy. And we expect to see that visa appointment wait times will increase. So it's always a good idea before your employees travel, make sure that you reach out to Immigration Counsel, make sure that they are cleared for travel, and that they know all of the steps that they need to take to re-enter the US. They have all of their documents in order. They're ready to go if they need to go to a visa stamping appointment. And we can help with all of that. So please reach out if you have questions. And with that, we have 3 minutes left. So we'll turn it over to questions. Justin, do we have any in the chat?
Thanks, Kelly. Yeah, so and good reminder there on travel, especially as we're approaching the holidays, always a popular time to travel. The consulates always get busier during travel time, and we should expect increased wait times this coming holiday season. So planning in advance, really critical, especially for very busy consular locations such as India. So just a couple of quick questions here. So one question, Kelly, was about the biometric RFE notices and whether they're only being issued for the sponsored employee, or if they can also be issued for spouses, such as, for example, H-4 spouses. And certainly they can be issued for spouses. I think, Kelly, we have seen primarily RFPs for the sponsored employee. I'm not sure that we have so far seen any for dependent family members, but certainly they could be issued for them. Another question is, do we know how long someone has been stuck in another country during administrative processing? Good question. So typically, if it's a more minor issue, a database needs to be updated with an approval. We usually see those resolved within a couple of weeks. If it's a background security check type issue, it could be several weeks, it could be several months. I have seen at times individuals stuck in administrative processing for many months. And if it is a security check issue, there's really no good way to expedite that, and consulate typically will not provide us much information regarding that. Okay, I think we probably have time for one more quick question here. So this question is about the $100,000 fee. And if an applicant has an expired H-1B with an I-140 approval and they're currently abroad, would the $100,000 fee apply to cap exempt? So not quite clear on the entire scenario there, but I would say that if they don't have a valid visa, they're not in the United States presently, and a petition is filed for consular notification because they're not in the US, then it is likely that the fee would apply in that scenario, if I'm understanding the facts correctly. With that, we are at time, so I think we'll need to end it there. And the HRCI codes for you there. Thank you all very much for attending. Appreciate your time. Let's see that this codes up for a minute for folks to get that. And I believe we'll be distributing the slides to attendees after the session. With that, we'll go ahead and end today's program. Thanks, everyone.